Howdy, Sun Devils, and welcome back to History 110. Today we'll be looking at the history of the U.S. Supreme Court since 1865. And now I'd like to start this lecture off by saying that our last lecture, The History of the American Press, went a little longer than I had hoped it would. So for this one, we're going to try to make up some of that time and move a little quicker through this, just touch on some of the big developments in the history of the Supreme Court. So to jump right into that, let's look quickly at the origins of the Supreme Court, which you might remember was established along with the other two branches of government, the executive, the White House and the presidency, the legislative, which is Congress, the House of Representatives and the Senate. It established our Supreme Court, and it was then fully developed under the Judiciary Act of 1789. Now, as you might be familiar, given all of the recent media coverage of some of these Supreme Court justice nominations, we know that the justices are nominated by the president first, and then they have to be confirmed by the Senate, and that once they are confirmed, they are then given a lifetime tenure on the court. And the reasoning behind this is that the founding generation of Americans wanted to try to make sure that those who became judges were as free from politics, from the need to campaign, to run for re-election, to be influenced by outsiders. They wanted to remove that as much as possible. And so that was the idea behind giving them lifetime appointments. Now, on the Supreme Court, we currently have 9 justices, and among them there is a Chief Justice. And now, while the Chief Justice still only has one vote, like everyone else on the court, they do enjoy a certain degree of authority over the court. Two of the most important privileges that they have is, one, they get to set the agenda every week for as the Supreme Court comes together and considers which cases it will hear. Because given the number of cases that are pitched to the Supreme Court, in reality, the court can only hear, I believe it's less than 1% of the cases that are brought to it. So setting that agenda and helping to decide which cases the court will hear is an incredible privilege and helps to shape the rulings that the Supreme Court eventually arrives at. And then once they arrive at those rulings, the second privilege that Chief Justices possess is that if they're in the majority opinion, that is, if they're in the group of justices who win the case essentially, that they have the opportunity as the senior ranking member to write the majority opinion. Because anytime the Supreme Court makes a ruling, it issues its opinion, which gives the background and the legal thinking which went into that decision. And now those who dissent, those who vote against the majority opinion, also get to write their own. But it's typically the majority opinion that goes into history and that has the greatest influence down the road. So the Chief Justice has those two privileges. And now if we look, again, you do not have to memorize all of this, by no means. Since 1865, we've now had 31 different U.S. presidents, but over that same time, we've only had 12 different Chief Justices, and here they are for you. And while we will touch on all 12's different courts, in reality, the ones that we really care about here, and you can pause here and review this if you'd like or come back to it, we're going to be looking at specifically these larger changes in the court. So just briefly, we'll see how after the Civil War, there was initially a rush of civil rights legislation that was passed, trying to protect the rights of these freed Black Americans now that slavery had been abolished. And yet, once these laws are passed, especially under the Waite Court, Morrison Waite's court, several of them get rolled back, and they get stripped back to just the bare minimums of the 13th and 14th Amendments. Then, there at the start of the 1900s, under White's court, is what's called the Lochner era. And this is a time period when the rest of the country is moving in a progressive direction of trying to defend workers' rights and fight back against corporate monopolies. But although local governments, state governments, Congress, and several presidents like Roosevelt, Taft, and Woodrow Wilson are on board with this, the Supreme Court is going to take a different approach. And they're going to strike down a lot of laws that would have protected workers. Then, during the Great Depression, there in the 1930s, when President FDR was trying to pass his New Deal legislation, the Hughes Court comes under a lot of fire because it's a divided court, and most of the cases came down to a single Supreme Court justice ruling either for or against FDR's New Deal programs. And as a result, FDR made his infamous threats to, quote, pack the courts, meaning that he would expand them from 9 justices to 15 and fill those 6 seats with friendly justices so that he could pass what he wanted to. And then for us living here in 2021, it's quite likely that the most influential court, the one that had the greatest impact on our lives, was that of the Warren Court. And so a lot of the civil rights and the civil liberties that we now almost take for granted were passed under Warren's court. And then, of course, today we are living under the Roberts Court, which has been, in comparison to other courts, one of the more conservative ones. Some of the big rulings have included those like Citizens United, which gave corporations freedom of speech and the right to participate in funding political campaigns. So, to get into this, at the beginning, we need to understand that the Supreme Court was incredibly weak. It was literally just a court that was set up. It was not the interpreter of the Constitution. It did not have nearly the powers that it does today. And in fact, in most cases, it was considered to be weaker than the state governments. The Supreme Court tried to change this in a case of Chisholm versus Georgia, where it decided that it could rule in instances where someone who was a citizen of one state could sue the government of another state. However, as soon as it gave itself that power over the state governments, those state governments came together through Congress to pass the 11th Amendment and essentially overturn this. They didn't want to give that power up to the court. This would be followed, though, by one of the most important cases in U.S. history, Marbury versus Madison. And this is the case there in 1803 where the Supreme Court gained the power of judicial review. This is the point where now it had the power to be the ultimate, the final interpreter of the Constitution. And through judicial review, what the Supreme Court is able to do is that if Congress passes a law and it's challenged in court, the Supreme Court can consider if that law actually meets the standards of the Constitution. And if it does, it's allowed to stand, and if it does not, it becomes what we call struck down. Following this, we should also note in the case of Worcester versus Georgia there in 1832, this is during President Andrew Jackson's administration, that in a ruling regarding the sovereignty of the Cherokee Nation there in Georgia, the Supreme Court endured what was likely its single greatest threat to its survival. Because this was a case in which Andrew Jackson had made it publicly known that he had no intention of enforcing whatever ruling the Supreme Court came to. And so the court was in a position where there was the very real chance that we could see the precedent of the president essentially vetoing the Supreme Court, which is by no means one of his constitutional powers. And so what the court actually did to avoid this disaster was that they published their rulings, but then they didn't issue the paperwork for the federal marshals to go down to Georgia and actually enforce it. They just kind of let that part slide so that it didn't force the direct confrontation there with President Jackson. And through that, they were able to sidestep this, what could have been a massive disaster. Okay, now even today, debate continues over how many justices should be on the court. We should be clear that the number of Supreme Court justices is not established by the Constitution. And this next slide is, again, by no means one that you need to memorize. This is just so that you can see how, over time, the number of justices has changed from 6 to 5, back to 6, up to 7, up to 9, up to 10, back down to 7, back to 9, where it has stayed, despite President Roosevelt's attempts there in 1937 to pack the court and expand it to 15. So since 1869, we have had 9 justices, with one of them being the Chief Justice. And politics have played a role throughout all of this. If you look up there at the 1801 bullet point, that was when President John Adams was leaving office, and he wanted to make sure that the incoming President Thomas Jefferson, who had very different views, could not use the Supreme Court to gain more power for himself. And so, as one of the Supreme Court justices was retiring, Adams convinced Congress to just simply remove that seat when that justice retired and not let Jefferson come in and fill it. Of course, Jefferson immediately restored that seat, and then later in his presidency added another seat to the Supreme Court. All right, now our first post-Civil War Supreme Court, the Chase Court. This court, not much to discuss here. They oversaw Reconstruction, and the Chief Justice there, Salmon Chase, oversaw the impeachment of Andrew Johnson. But by and large, at this point, the federal government was largely controlled by the radical Republican faction, which was passing its Reconstruction legislation, and the court kind of just stayed out of the way. The most important court case that they heard was likely Texas v. White, in which 5 years after the Civil War, we finally had an official Supreme Court ruling over whether the secession of the states had been legal or illegal. and it was ruled to be illegal. This was followed up by one of the most disappointing courts, the Waite Court. The Waite Court was the one which, following the legislation passed by radical Republicans during Reconstruction, began to then go back and reconsider these laws. And a bundle of these cases were known as the civil rights cases. So this is not just one case, this is a whole bundle of them that has made its way up to the Supreme Court, so that the Supreme Court can examine, okay, how do these laws look in light of the Constitution, and specifically the 13th and 14th Amendments. And under the Waite Court, they found that the 13th Amendment just simply abolished slavery, and the 14th Amendment only dealt with discrimination that might occur between the federal government and citizens. The court ruled that between state governments and their citizens, and between private businesses or even public accommodations and citizens, discrimination on the basis of race or other factors was constitutional. And now we should note that this was an 8-1 decision, that 8 Supreme Court justices decided to support this decision and only 1 dissented. And so to give us an idea of just how surprising in some ways our Supreme Court justices can be, that we tend to want to think of them in terms of our modern day, left, right, liberal, conservative kind of breakdowns. A lot of these rulings in these cases could be surprising when you see the backgrounds of different justices. So in this case, we have a justice from Massachusetts, one from Kentucky who was an abolitionist, one was from Connecticut, practiced law in Ohio, another from Connecticut, practiced law in California, one from New York, one from Ohio, another from Ohio who was actually well known as a fairly progressive judge and who had even extended 14th Amendment protections to non-U.S. citizens. All 8 of these had ruled against the civil rights cases, in that racial discrimination in non-federal settings was constitutional. And in fact, the only dissenter here was Justice Horace John Harlan, who had actually been born into a wealthy slave-owning family in Kentucky. And although he had supported the Union, he had opposed the Emancipation Proclamation. However, despite this, Justice Harlan was committed to the idea that the poor in society should be cared for, and he believed that Reconstruction had given the federal government new powers over the states, which could allow them to actually enforce some sense of social equality at the ground level. He not only was the only dissenter in the civil rights cases, he would be the only dissenter in Plessy versus Ferguson, which is where we see separate but equal established in our country. In fact, he was nicknamed the Great Dissenter because he was often in the minority opinion. And then the second major case under the Waite Court, along with the civil rights cases, was that of Reynolds versus the United States. And I point to this case because this is the first time that the U.S. Supreme Court had brought Thomas Jefferson's famous quote of the wall of separation between church and state into the court and used it to help rule on a case. Now, we should note that Jefferson's quote here is not from the Constitution. It's not from the Bill of Rights or any official founding document. It's actually taken from a private letter that he had written to a group of Baptists back in the day to reassure them that the United States was not on a path to establish some kind of national church, that there wouldn't be one single faith that was established and which would then in turn persecute groups like them, that they would be free to practice their religion as they saw fit, and that they would be the ones protected by this wall of separation of church and state. So when it was originally written, it was an encouragement to religious groups that the state wouldn't persecute them. And since then, it has become incredibly influential in cases deciding influence going both ways, in a sense, as to the extent to which the state can influence religious beliefs and practices, and to the extent to which religious beliefs and practices should influence the state. And as you might imagine, that debate continues to rage on today. Moving on to the Fuller Court. This is another disappointing court. More so because, given the Chief Justice last name, as a Fuller myself, I sure wish the legacy here was a little different. It's actually under the Fuller Court that we see Plessy versus Ferguson and the separate but equal ruling. This was a case in which a man named Homer Plessy, a black citizen of Louisiana, had intentionally boarded a train and sat in one of the cars that was reserved for white passengers until he was arrested so that they could challenge this law. And yet, rather than ruling that discrimination in public accommodations like motels and railroad cars was unconstitutional, The court rules almost unanimously that it is protected, that it is constitutional. And this would not be overturned until Brown versus the Board of Education in 1954. Now, as the lone dissenter again, Justice Harlan had written in his opinion that in his view of the Constitution, that in the eyes of the law, there is in this country no superior dominant ruling class of citizens. There is no caste here in the United States. Our Constitution, he wrote, is colorblind and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law. And then, in a stunningly accurate prediction, Harlan wrote that, in my opinion, the judgment this day rendered will, in time, prove to be quite as pernicious, as evil and upsetting, as the decision made by this tribunal in the Dred Scott case. Not only did the Fuller Court rule in favor of separate but equal with Plessy versus Ferguson, but it also ruled against workers' rights and protections in Lochner versus New York. And this case right here is important because it's going to initiate what's now known as the Lochner era. And while the Lochner case itself wasn't necessarily a major one, it just simply referred to a law there in New York which put a limit on how many hours you could force a baker to work. The court struck down this law, saying that it violated personal freedom. But what it signaled was that this was the start of the U.S. Supreme Court here in the early 1900s of ruling more so in favor of big businesses and more so against the rights and protections of workers. So this is a time period when, as we noted, local governments all the way up to the presidency were really in favor of increasing workers' rights, giving them the right to strike, giving them laws protecting minimum wages, protecting against being forced to work too many hours. And the Supreme Court at this point is going to be on a different path. And it begins here towards the end of the Fuller Court, but then it fully develops under the White Court following that. So this is where we see the rise of the Lochner era. And so again, they strike down the number of hours people can work. One of the practices of that day were what were called yellow dog contracts. And these were contracts in which employers could demand that in order for an employee to be hired, they had to sign the yellow dog contract. And by signing the contract, they gave up the right to do things like joining unions or perhaps going on strike. And while there had been laws in favor of the workers saying that it's illegal to make them sign these contracts, the court ruled that no, actually, businesses are free to demand that employees sign these contracts. So this is what the White Court is most infamous for. This was followed up by the Taft Court, and of course, William Taft, having previously served as the president, the head of the executive branch, now served as the head of the judicial branch, as our Supreme Court justice. There were not many highly influential cases during this time, but one that I might point to was that of Buck v. Bell. And you don't need to memorize this one necessarily, but just in particular to give you an idea of how prevalent the idea of eugenics was at this time. This was a court case in which the court ruled 8-1 that the forced sterilization of what they called the, quote, feeble-minded, those who maybe had suffered traumatic brain injuries, those who had different mental illnesses. This encompassed a wide range of conditions here. That the feeble-minded and unfit, their forced sterilization did not in fact violate the Constitution. So any arguments to like rights of privacy or liberty or cruel and unusual punishment, none of that applied in this case. This was ruled constitutional, and even to this day, this ruling has never officially been overturned. And one of the reasons why I point to this particular ruling is because while this lecture is focused on the Chief Justices themselves, during Taft's court, the most famous and well known of the justices of that time was that of Oliver Wendell Holmes Jr. And looking at his majority opinion that he wrote here in this case, in comparison to some of his other rulings, shows you just how complex our justices have been. So in writing the majority opinion of Buck v. Bell, we hear eugenicist ideas coming through very clearly, because despite Oliver Wendell Holmes being one of the most progressive justices of the time, he had been appointed by President Theodore Roosevelt because Roosevelt loved how committed he was to issues like free speech and opposing corporate monopolies and trying to work their way back to protecting workers' rights. In this case, Holmes's opinion was that it is better for all the world if, instead of waiting to execute degenerate offspring for crime, or let them starve for their imbecility, society can prevent those who are mentally unfit or manifestly unfit from breeding their kind. The principle that sustains compulsory vaccination is broad enough to cover cutting fallopian tubes. 3 generations of imbeciles are enough. And so we actually see the court here ruling that in the interest of public health and social well-being, they felt that the U.S. government and the states had the right to forcibly sterilize people. So this right here should give you an idea of just how influential these kinds of scientific ideas like scientific racism, eugenics, they dominated a lot of American thinking during the early 1900s. Then we get to the Hughes Court. Now, the key with the Hughes Court is that here we are coming into the 1930s. We're in the midst of the Great Depression, and President Franklin Delano Roosevelt, President FDR, is trying his best to radically reshape and expand the federal government to try to pull the nation out of this depression. And what we call this program that he put in place is the New Deal. Unfortunately for FDR, although Congress was generally willing to pass his programs, when they were then reviewed by the Supreme Court, they often ran into a lot of roadblocks, and that was because the Supreme Court was highly divided at this time. You had what was known as the Four Horsemen, who were the 4 conservative justices who typically voted against FDR's programs. You had the 3 Musketeers, and I'm being serious, these were how they referred to themselves and how the press referred to them. They were the 3 liberal justices who almost always supported FDR's programs. And so in between those 2 groups, you had 2 swing votes. You had Chief Justice Hughes here, but he tended to lean more liberal. He could on occasion side with the conservative faction, but he tended to lean liberal and thus support most of FDR's programs. So in most of the cases involving the New Deal, it came down to a single vote by Justice Owen Roberts, who was somewhat in the middle between the 2 groups. However, because FDR was in fact trying to expand the government so rapidly and so dramatically, in many cases, Roberts took a more strict interpretation of the Constitution and ruled against FDR, which, as you might imagine, did not please FDR, and it was as a result of this that he made his infamous threats to expand the court, to pack it in a sense, and expand it from 9 justices to 15 justices, and fill those additional 6 seats with friendly judges who would support his programs. Now, during this court, there's really one case that I want us to focus on, and it's not necessarily because this case itself was a major one or had dramatic stakes. It involved the case of a California maid who was suing regarding minimum wage laws. Now, why this case was so important was because there were 2 big results that came out of it. The first was that it was in this case that Justice Roberts, who had been that swing vote, he kind of realized that if he sided with the conservative faction and shot down another, workers' rights, kind of tying into that New Deal liberal attitude that FDR wanted to see, that if he ruled against that again, that it just might be what pushed FDR over the edge and caused him to actually follow through with his threats. And so on account of this, we see Roberts switching his vote, trying to appease FDR, and most importantly, trying to hold the integrity of the court together, because what no one wanted to see, Congress didn't want to see it, the Supreme Court didn't want to see it, FDR's own vice president didn't want to see the precedent set of any time a president couldn't get their way or pass their programs, that they just added new seats to the court. Because then you would see the court go from, say, 15 to maybe 20 or 30 or 50 or 100. There was no cap on the number of justices that could be appointed. And so Roberts switches his vote, and it's become known as the switch in time that saved 9. The other important thing is that by ruling in favor of a minimum wage law, this signaled the end of what we had called the Lochner era. And so now the Supreme Court is becoming more receptive to protecting workers' rights. And then the Stone Court. Now, despite FDR's threats to pack the court, in reality, he ended up serving 4 consecutive terms. And by the end of those 4 terms, by the time that he passed away in office there in 1945 at the end of World War II, he had actually appointed 8 of the 9 sitting justices. So in the end, he didn't really need to pack the court to get his way. And yet, despite 8 of the 9 justices having been appointed by the same president, the Stone Court, which came here during the years of World War II, was infamous for its inability to get along. And as a result of their quarreling, as a result of the country being, largely preoccupied by fighting in World War II, there aren't many major decisions made during this court. Perhaps the most influential one is that the court didn't really oppose the internment of Japanese Americans during the war. That when this was challenged, they ruled in favor of those federal programs of internment. The Stone Court was followed by the Vinson Court, which oversaw the end of World War II and the start of the Cold War. It was not as divided as the Stone Court. During Stone's Court, it was more of personality conflicts that drove a lot of the division. Under Vinson's Court, it was really more of an ideological one, in that several of the justices favored what's known as judicial restraint, which meant that they interpreted the Constitution and evaluated laws in a stricter sense, that they weren't necessarily looking out at present social conditions to try to determine what would be best for the country. This was in contrast to those who favored judicial activism, which was, in a sense, the idea that you would look out at the state of society and you would try to align the law with the needs of the people, as opposed to strictly aligning it to the Constitution. And so because of this divide there in the court, we don't see many major decisions being made. However, the issue of judicial activism would be absolutely embraced by the upcoming Warren Court. The Warren Court was by far the most liberal and activistic court in history, that through their rulings, many of the civil rights and liberties that we just take for granted today, these things were established during these years in the 1950s and 60s. Now, Warren himself, although he was committed to expanding these civil rights and liberties, might have made some surprising decisions when you look at them all together. So, for example, prior to joining the Supreme Court, when he was the Attorney General of California, he had in fact supported the violation of many civil rights and liberties through the internment of Japanese Americans during World War II. Then, as the Chief Justice of the Supreme Court, he oversees the dramatic expansion of such liberties and rights. And so here is just a brief rundown of some of the things that were ruled during his court. And among these, I'll point to the Brown versus Board of Education ruling as one that you should probably know. At the end of this PowerPoint presentation, I've got just a quick study guide of the 10 most important cases, the ones that you should be familiar with. The other ones, not really. Just be familiar kind of with the general idea of how these courts are changing over time. But this is one of the few cases that you probably should know. And so to give this rundown, during Warren's time as the Chief Justice in the Supreme Court overturns separate but equal. It ends official school prayers. It bans racial discrimination in public accommodations like hotels. It strengthens the freedom of the press. It requires police to inform citizens of their rights. It legalized interracial marriage across all of the states, and it protected free speech, even in the offensive cases like those of KKK speakers. So all of this took place under the Warren Court. Following Warren's court, the final 3 begin a turn towards more conservative approaches to things. However, although they're turning conservative, we might be, again, surprised by some of the rulings that have been passed during these times. So, first of all, we have the Burger Court. And although it was more conservative than Warren's court, it at no point overturns any of the major decisions. Those different civil rights rulings are still in effect to this day. Without a doubt, the most important issue that the Burger Court heard was that of Roe v. Wade and the issue of abortion there in 1973. And this, as you might imagine, was a highly contentious ruling that ultimately came down to the court's ideas of the right to privacy. That given that individuals had the rights to manage their own reproductive health, reproductive decisions, things like taking contraception on their own, and given the fact that patients and physicians have a right to privacy, this, according to the court, didn't leave really much of an opportunity for the government to step in between people in those decisions and regulate or outlaw them. So through Roe v. Wade, the court overturns many, many anti-abortion laws. However, it doesn't make an ironclad decision necessarily one way or the other. And in fact, the court in its ruling adopted a kind of trimester framework, which, as many of you might know, there are 3 trimesters in a typical pregnancy. They ruled that during the first trimester, the government could not regulate abortion. During the second trimester, it could impose reasonable regulations and requirements, and that it could outlaw abortion in the third trimester, as long as there were exceptions made for instances where you need to say, save the mother's life. Now, since then, as scientific understanding and medical technology have improved, the Supreme Court has revisited some aspects of this, and it no longer bases it on a trimester framework, and instead it takes a more nuanced view of fetal viability. Now, we should also note that the Supreme Court here in Roe v. Wade did not attempt to answer the question of when human life begins. And in fact, they were explicit in their ruling when they said that when those trained in the respective disciplines of medicine, philosophy, and theology are unable to arrive at any consensus, the judiciary is not in any position to speculate as to the answer. So they did not try to answer that question. And instead, this was based on the right to privacy, which, if we remember from the previous lecture, The History of the American Press, the right to privacy legal argument emerged because those yellow journalists there in 1890 had crashed the wrong lawyer's wedding and annoyed him. So this just gives you an idea of how influential that right to privacy article back in the 1800s ended up being. All right, Burger's Court was followed up by the Rehnquist Court, which was even more conservative and began a trend of shifting some power from the federal government back to the states. However, it's during this court that we see the upholding of the right to protest, even to the extent of burning an American flag in public. Not only that, but it's during this court that many, many anti-homosexuality state laws were overturned. Moving closer to the present, with the Roberts Court, this court, even more conservative than the Rehnquist Court, and according to most legal scholars, the present Supreme Court is roughly on par with, say, the conservative courts of the 1940s. Now, although it is one of the more conservative Supreme Courts in history, under it we have seen issues like climate change be officially recognized by the court. And so, for example, in the 2007 case of Massachusetts versus the Environmental Protection Agency, the court ruled that climate change science was valid and that as a result of that, the EPA had the power to regulate automobile emissions. In addition to this case, they also ruled in Citizens United versus FEC that the rights of free speech and political expression should be extended even to corporations, and therefore independent organizations not officially associated with candidates were now constitutionally allowed to spend as much money as they wanted to on campaigns. And within just a few short years, from when this ruling was made in 2010 to 2014, the amount of money spent on Senate elections had already doubled by that point to nearly I'm going to get that number wrong. I need to look it up. But the amount of money spent on this had doubled by that point. And then, more recently, in 2015, the Roberts Court legalized same-sex marriage nationwide. And this took place when a gay man who was dying in, I believe, Ohio, wanted to have his partner listed on the death certificate. This was forbidden under state laws. It was taken to the Supreme Court, and the Supreme Court ruled that that state's decision had been unconstitutional. And so this was when you saw the famous pictures of the White House lit up in rainbow colors, and this took place under the Roberts Court. So, one final thought is that although recent coverage has painted the current nominations of Supreme Court justices as particularly contentious, in reality, justice nominations have always been contentious. What we might say has been different here recently is that these nominations have received much greater media coverage. And so, really, for kind of the first time with, say, the rise of the 24-hour news coverage model, now you can follow along. The average American in real time with the Senate proceedings of these nominations. And so this is one of the reasons why issues like the nomination of Merrick Garland and subsequent ignoring of it by the Senate, the contentious hearings of Brett Kavanaugh and then Amy Coney Barrett, these have been much more in the public's eye, say, than previous ones. But contentious nominations to the Supreme Court have been a regular staple of U.S. history. And so that wraps us up for this lecture. I'm going to leave you guys with a quick study guide here at the end.